Now that I kept you in suspense for an hour, we can bring you forward and go from there. I'm going to first, again, as we've done, bring up the two semifinal teams, give them their awards, and then we'll bring up the two finalists, do a coin toss, so give you a few minutes to compose yourselves, and then we'll go forward and start the final round. About 5 minutes, so very short turnaround time, which is good. So, if I can have our first semifinalist, Benjamin Mills and Zachary Gappa. And Amy Medeiros and Miranda Prophet of Fitchburg. All right, so if we can have the finalists then. Joey Petrovich and Lindsay C. of Patrick Henry College. And Allison Bain Lucy and Matthew LaRoche, University Hall.
Okay. All right, we'll begin. Petitioner.
May it please the Court, my name is Allison Bain Lucy, and I'm representing the petitioner, the City of Nur, the State of Olympus, and Parks Director Samantha Summerman on the issues of free speech and free exercise. My co-counsel, Matthew LaRoche, will be presenting the issue of the Establishment Clause. Petitioner respectfully requests 3 minutes reserved for rebuttal time. Let me begin by reviewing the facts of this case. In July of 2004, Reverend William Denolf applied for a permit to use the Jones Park in the City of Nur to present a Passions play as well as to erect a freestanding cross for 3 days. This application was granted through the initial application process. However, upon regular review by the City Council, issues were raised and the application granting was postponed until after the election season. Throughout the election season, extreme divisiveness became apparent within the community, and eventually elections were decided almost solely based on council members' positions on Reverend Denolf's application. Ultimately, 3 members voted yes and 3 voted no, with the mayor breaking the tie, and Reverend Denolf's application was denied due to a compelling interest in the Establishment Clause. Your Honors, this is not a case of discrimination, but rather a case of the state's need to comply with the Constitution in order to avoid an alienating and dangerous relationship between church and state by establishing a religion. Today, petitioners will present these points. Based on the speech and non-speech aspects of Reverend Denolf's application, his permit could have been denied through a legitimate government interest based on the O'Brien test. However, petitioner can prove through strict scrutiny tests that they act in a neutral content-based limitation due to a compelling interest in the Establishment Clause. They acted through means which were most narrowly tailored. They did not have prior restraint. They did not violate Reverend Denolf's rights to free exercise. Reverend Denolf applied for a permit using both a freestanding cross as well as a play. This combined speech and non-speech aspects. In the case of O'Brien v. United States, this court recognized the legitimate interest can deny this application. However, petitioner can prove through strict scrutiny that this application was denied in a content-based manner. This is not viewpoint-based discrimination. Yes. Your Honor, viewpoint-based discrimination would be if the city were discriminating against Reverend Denolf's religious viewpoint. However, this is not the case. In this case, they denied religion during the Easter season because of the divisiveness and the endorsement issue at hand, and therefore they made a content-based limitation through the only means available to them. Also, it is important to recognize that although Jones Park is a park, it is not within the keeping of a traditional public forum. It has a permitting process through which all applications must go, and it has no history of advocacy in religion within the park, and also looking at other...
Necessarily preclude it, just because there's no history, does that necessarily preclude it from being used in this way now?
No, Your Honor, that is not the case. However, in Establishment Clause cases such as Allegheny versus the ACLU, this court has looked at the history and context of a given forum, and Jones Park has not had a history of purely religious presentations within its forum.
But hasn't the Easter egg hunt, that arguably defined as a religious activity that was held by the Young Men's Christian Association for Easter?
Well, Your Honor, the Young Men's Christian Association would fall within the category of a community group, and the Easter egg is what we would call a secularized symbol, such as the Christmas tree, this course recognized in cases such as Lynch v. Donnelly.
Why would this not also fall into the purview of a community group? After all, for years it had been attended by diverse members of the community. Isn't that also a community group?
It would be erroneous to construe the community's interest in Reverend Denolf's play as some secularization of Reverend Denolf's play. It is purely religious, and it takes place with the FBC, the First Baltic Church, and Reverend Denolf. This is an Easter celebration from a particular religion, and it caused divisiveness and threatened endorsement within the community, and therefore a content-based limitation was made based on the Establishment Clause.
How do you get over the hurdle, though, of a public park traditionally being a traditional public forum, not subject to any government regulation?
Your Honor, petitioner recognizes that parks are traditional public forums. However, in this case, the history and the context does not withstand. Also, in the case of Frisbee v. Schultz, limitations have been made on public forums such as streets and parks. Therefore, this action is not alien to the court.
But aren't those limitations subject to particular guidelines that they must follow in the permit process?
Your Honor, there are guidelines which all governments must follow. In this case, the guidelines which the City of Newark set forth was the Constitution. This is not prior restraint. Any reasonable government acts within the keepings of United States law and tradition, and therefore the City of Newark acted based on the mandate of the Constitution and the Establishment Clause and denied Reverend Denolf's application. The standards were not lacking. In this case, the Constitution existed, and it was the City Council's job to make sure that the City Council and the City of Newark complied with laws of general application as well as the Constitution, and that is exactly what they did.
Go ahead.
Sorry, go ahead.
I was going to say, the city councilors are not constitutional scholars, however, number one. And number two, it was a very, very close call, even when they voted on it. 3-3, and the mayor broke the vote. Is that correct? I think that's correct.
Yes.
So, that being the case, is it fair to say that the standard that governs the permit was the very constitutional question that the council may or may not even have been qualified to analyze?
Well, petitioners recognize that City Council are not legal scholars. As my co-counsel will prove, this was an Establishment Clause violation. The City Council acted in the correct manner, and the fact that it was a 3-3 vote just further illuminates that the political divisiveness within this community was so great that it would have caused an Establishment Clause violation.
I'd like some elaboration on that standard. We've heard you make that statement a number of times. You use the word standard. Would you elaborate on how that's functioning here?
The standard of narrowly tailored means, or?
The standard that was used to make that decision, I'd like you to think that out for us for a
The
moment.
standard was the Establishment Clause, and therefore the City Council would have looked at such things as endorsement, which was risked, as my co-counsel will speak about, and also the divisiveness within the community. And in doing so, they were mandated to make a narrowly tailored-based decision, and that's exactly what they did. Any other option would have caused further entanglement and perhaps discrimination against Reverend Denolf. Ideas of a disclaimer would have been discriminatory because no other group was subject to a disclaimer, and separation of the cross and the play or further altering of Reverend Denolf's application also would have fostered entanglement, which was simply not allowed based on the Establishment Clause. Therefore, the City of Newark did act in a narrowly tailored manner, making a content-based limitation in this case.
I guess, counsel, I have a problem with you making the claim that there's a narrow, objective, definite standard on the Establishment Clause because you're relying on the Constitution. Wouldn't the Constitution apply in every single case?
It would apply in every single case, and this is the first case that has come before the City of Newark based on the facts in this case, and therefore, City of Newark acted to make the best decision they could regarding the Establishment Clause without violating free speech of all the community members of Newark. They made a decision based on Easter applications because the City of Newark does not wish to discriminate against religions or disclude religion from Jones Park. They simply had to act in this case due to a compelling interest in the Establishment Clause, and they did so in a content-based manner and through narrowly tailored means. And that is exactly what the Establishment Clause requires.
There were no standards, however. There were no written standards to guide the council, other than, as you say, the constitutional issues. How do you square that with the two cases, pertinent cases? I think one is Metco and the other one is Shuttlesworth. How do you square your argument with the conclusions in those two cases?
Your Honor, those cases differ because other religious groups had been allowed availability in the park, and this was not the case in Jones Park. No other religious group had ever been allowed. Therefore, the City of Newark is following the same standard for all applications in an attempt to comply with the Constitution. Thank you.
May it please the Court, my name is Matthew LaRoche, and again, I'll be representing the petitioner, City of Newark, State of Olympus, Samantha Sutherland, as the Parks Director, as to the issue of the Establishment Clause. The Establishment Clause expressly states that Congress shall make no law regarding the establishment of religion. But what the Establishment Clause creates is a compelling state interest to maintain a separation between church and state. This compelling interest is what has guided the City of Newark in preventing Reverend Dinoff from utilizing Jones Park. In essence, this case is about the City of Newark responding to a politically divisive issue involving the intermingling of church and state with a narrowly tailored policy which is governed by the mandate of the Establishment Clause. Petitioners today will present 3 points to this Court. First is that any other response by the City of Newark to this permit would have violated the Lemon Test. Second, that the political divisiveness present in this given instance further fosters excessive entanglement between church and state, again, looking at the third prong of the Lemon Test. And finally, allowing Reverend Dinoff to utilize Jones Park would convey certain governmental endorsement of religion and thereby violate the endorsement test as established by this Court in cases such as Lynch v. Donnelly and Capitol Square v. Panetti.
What's the religion endorsement? The church is doing nothing other than, the city is doing nothing other than allowing a group to use the park.
Certainly, Your Honor. When you're looking at cases with the endorsement test, there's 2 principal points. Does it foster excessive entanglement between church and state? And does it convey certain promotion or demonstration of approval or non-approval to certain religious sects? Now, what the endorsement test looks at is the perception of the reasonable observer. The reasonable observer is not applied to an individual. It's applied to a community ideal. Now, the community ideal of the City of Newark would be a community feeling that having a freestanding cross represented by the FBC would convey a demonstration of approval, would convey to members of the FBC that they're full members of society, they're not outsiders. The City of Newark endorses their beliefs, they promote their beliefs. It would send another message to non-FBC members that they're not adherents, that are not adherents, that they're not full members of society. This is what
Would you argue, though, Counsel, that because the divisiveness that this created in the community, and there was an election, and the election was very, it was clear that, some of the community was for, certain candidates and some were against. So I don't know how you can say that the community feels one way or the other because obviously the community is divided.
Your Honor, you're exactly correct. And the principal point there is that it's going to send a message to people that are on either side that the City of Newark has responded to the winners and said that we will let you have the cross in the park. That sends a significant message of endorsement and sends a message of promotion that the city is trying to prevent. They're trying to prevent that by not violating the Establishment Clause. And how have they done so? They've created a narrowly tailored policy which effectively looks at this given instance and how are you going to solve this without violating the Establishment Clause. Now, respondents might add an equal access policy would be in line with this Court's jurisprudence, but that is simply incorrect. If you look at cases with equal access policies, a neutrally acting policy can still violate the Establishment Clause. How could it do so? In a case such as Whitmer v. Vincent, this Court recognized that a religious group could dominate a forum in such a way that it would violate an equal access policy and violate the Establishment Clause.
But in this case, they're the only ones who've applied, aren't they? So it's not a question of dominance, it's just a question of being the first ones there, and someone has to be first.
Certainly, Your Honor, and the City of Newark is not taking the position that we would not like religious activities to take place in Jones Park. They're responding to this specific issue. If you look at a case such as Lynch v. Donnelly, this Court cited that every religious action must be taken into context of the specific circumstances of that action. In other words, history and context are essential. In Allegheny County, versus the ACLU, this Court ruled that a nativity scene violated the Establishment Clause because that forum was not open to all on an equal basis. This is significant.
Wasn't there another very important reason why the Court overturned that? And wasn't that because the county actually was soliciting people to come there? They sent out flyers and so on?
Certainly, Your Honor. But the principle that was taken away from Allegheny by this Court is that the history and ubiquity of the practice is essential when looking at possible Establishment Clause violations. If you look at the history of Jones Park, this has not been used by religious organizations in this manner. No park on the record or in any of this Court's jurisprudence has had a freestanding unattended object displayed in this method and been allowed to not violate the Establishment Clause. There's essential differences between this case and cases such as Capitol Square v. Panetti. Again, this would get back to the second prong of the Lemon Test. It would have the primary effect of advancing the FBC and advancing religion in Jones Park over non-religion or non-adherence to the FBC.
Why? It's not compelling people to go. It's not compelling people not to go.
Certainly, Your Honor.
It's there. It is available for those who want to come or not come.
Certainly,
but of course it's going to be held by dint of the popularity itself. It's grown and grown.
Certainly, Your Honor, but this sends a message to the community as well. This play has been becoming more popular. Part of the community might not want to be part of the FBC, might not want to see the FBC in their public park. That
And
sends
they
a
make that election. They make the election not to see it. Go ahead.
Certainly, Your Honor, an election should not be decided based on religious content. Again, that speaks to the political divisiveness that was present in this given case, and it's an aggravating factor in the excessive entanglement between church and state.
But is
Now,
there really a risk that anyone in this community, after all that this community's gone through with the political divisiveness, is there really a risk that anyone is going to think this is an endorsement by the city?
Your Honor, it would be petitioners holding that there certainly would be. That if the city was to allow, after the political divisiveness present in this given instance, if they were allowed the FBC to utilize Jones Park, that sends a definite message to people that were against having the FBC utilize the park that the city of Neur is in fact endorsing the FBC. They're in fact endorsing this religious message. That's not what the Establishment Clause wanted of the government. The government.
Isn't there a risk that the other side, the people who are in favor of this play being conducted in the park are going to feel that the city has told the FBC, we're not interested in your group being part of our community? Isn't the same risk there?
Certainly, but that risk is removed from the city, from the government, because the government has created a narrowly tailored policy. We're not just targeting the FBC. It says deny all future Easter applications by the FBC and any other church group. It's not targeting the FBC. We're targeting a particular divisive issue with this particular context. Again, it's this specific context that turns this case.
How do you make the leap from approval to endorsing, allowing to endorsing? Those are two very different things.
Certainly, Your Honor. This court has recognized that endorsement, as they have defined it, being a demonstration of approval. That's what this court has defined in Capitol Square v. Panetti, Justice O'Connor.
How does it demonstrate it?
Certainly. Your Honor, again, this would send a definite message to the community that there is a demonstration of approval.
Implicit message, but definite?
Your Honor, it was petitioner's contention that that message can and will be sent. If the city of Neur is allowed to, or allows the FBC to erect, not even in addition to erecting a cross, but in addition to that, allowing a play from with significant religious components to it in Jones Park, there's a significant, definite, actual risk of governmental endorsement of religion.
It has some historical context, too, does it not, this play? This Passion Play has some historical context that takes it out of the religious realm, isn't that the case?
Certainly, Your Honor, but I would like to cite that this case is different than other cases that have cited the more historical context of a case such as a nativity scene. During this specific period, seen by the record, is obviously a highly divisive period over the traditional time of the Easter period. Again, during the Christmas season, you can expect to see a Christmas tree. You can expect to see a menorah. You can expect to see these things in a public park. This is the history. This is a tradition. Those objects have become secularized. I have seen no citing by this court that an unattended, freestanding cross has been secularized by this court's jurisprudence. That is simply not the case. It puts the government in a position during a highly divisive issue, during a highly divisive time period. We cannot even decide when the Easter period is, and that's not the decision should not be the decision of the city of Neur.
But would you agree that there's some secular parts of the church's desire to use the park, and therefore that this case does fit more squarely into the Lynch holding, where as long as there's secular objects to dilute the message of the religious objects, it's okay?
But there are no, Your Honor, there are no unattended, or there are no other objects in this given instance, and asking Reverend Denoff to have to put other objects discriminates against religion even more. We have not asked may I finish? We have not asked other groups to use other objects or add other objects to their displays. We are remaining neutral on this issue with a narrowly tailored policy governed by the mandate of the Establishment Clause. Thank you.
May it please the Court? My name is Joey Petrovich. Together with my co-counsel Lindsay C., I represent the Reverend William Denoff, the respondent in the case at bar. Your Honors, neutrality is the hallmark of the Establishment Clause, as we find that this Court has said in Everson v. Board of Education that is neutrality both to religious and non-religious groups. It is our contention as respondents today that allowing the by allowing the display of the freestanding cross, by allowing the religious play of the First Baltic Church, that we send a message to the community that all religions are allowed and that all religious expression is constitutional.
But counsel, can't you be just as neutral by disallowing all of them as well?
No, Your Honor. We find that the court calls this a callous indifference toward religion in Zorak, or toward religion in Zorak versus Clausen, when we have held that we cannot prefer non-religion over religion. This court, following from that neutrality principle, has distinguished two categories of speech that is connected to the government.
Let me interrupt you. So is there any way that the city of Nur could disallow someone with a religious message from conducting a performance or placing something in the park?
Certainly, Your Honor. Content-neutral time, place, and manner restrictions are constitutional. Now, and this is what prevents a forum open to all and equal access policy from being dominated by one religion. Petitioners contend that this forum will be dominated by the First Baltic Church, but that's not the case. By having an equal access policy, the city council can have time, place, and manner restrictions, restricting the time it can be used by religious groups, and so that one religious group is not dominating it. So an equal access policy is still neutral.
Isn't that what they're saying, though? Isn't it a time they're saying we're just not going to allow religious groups to perform or conduct any religious exercises in the park around Easter?
Certainly not, Your Honor. This is a clear case of viewpoint discrimination. My co-counsel will cover this when she talks about free speech. But when we're talking about different sorts of content, that is, content is a category rather than a viewpoint expressed in the category. So you have the category of a theatrical production, as well as the category of Easter celebrations being performed from a secular viewpoint, the Easter egg hunt from the YMCA, as well as the Shakespeare plays. However, it's viewpoint discrimination to say that those same theatrical productions and those same Easter celebrations cannot be participated in from a religious viewpoint. And so, Your Honor, no, it's not a content-neutral time, place, and manner restriction when the county says no Easter celebrations from any religious group. Rather, it's viewpoint discrimination, which this court has ruled to be axiomatically unconstitutional.
But how do you distinguish your position from the Allegheny case? I mean, that was a courtroom, a courthouse with a nativity scene. How is a public park with a cross any different? This court's ruled we're not going to allow a nativity scene in the courtroom.
This goes back to my original distinction between government speech and private speech on government property. The case in Allegheny County versus ACLU is clearly government speech for several reasons. First, and Capitol Square Review Board cites a footnote 50 of Allegheny County saying that the creche display there was the only one allowed on the grand staircase in the county courthouse. This makes it government endorsed religious speech because that no one else could display their creche there or their cross or the menorah, etc.
How do we know no one else could? Was there any evidence in the decision that said other organizations had requested that?
Yes, Your Honor. What we see in Allegheny is an ongoing relationship between the county and the Holy Name Society, who is the owner of the display, the creche display. A second difference, I think you've pointed this out, is that the county sent out flyers announcing the display and saying, come see the display, come see the carols performed in front of the display, clearly an affiliation. But finally, we find that the display had a sign next to it that said, donated by the Holy Name Society, and this implies a couple things. First, it implies ownership by the government of the display. It was donated from the Holy Name Society to the county, and so there's actual property ownership involved. But secondly, it implies endorsement of the Holy Name Society by the county government itself, and we don't have anything like that in this case. Rather, we have in the case at bar, we have a religious, or excuse me, we have a
Stop you there, counsel. If I give you a gift, then by accepting the gift, you're endorsing what my beliefs?
Well, if you give me a creche and I display it and don't allow any displays otherwise around it, and send out flyers saying, come see my display, then yes, I'm endorsing it.
Were other displays not allowed, or were they just
Yes.
not presented?
Yes, Your Honor. Other
Were
displays were
precluded?
not allowed on the grand staircase. They were allowed in a different forum. That's where the menorah was, and that's where the Christmas tree was. They were not allowed on the grand staircase, and that's the key difference. An open access, equal access, neutral policy in this case would temper that.
Are there any other symbols at the park?
Not at this current time, but that is not what
What
this
about
court...
the signage?
The sign-
Welcome to such and such park.
That I would contend is part of the park itself, just like the trees or a swing set that the city has put up.
Welcome to such and such municipal park, and then you've got a cross next to it?
Yes, Your Honor. I think you may be referring to the reasonable observer standard, saying a reasonable observer might somehow contribute the cross to the county, but that is not the case for a couple of reasons. First, we find that there's a history of this play being performed at the First Baltic Church by Reverend William Dinolf for the past 10 years. Anyone familiar with the context and the history in this community would not say that the city council is somehow endorsing the cross or endorsing the play. We find the reasonable observer would say, well, this is just part of the Easter celebration that the First Baltic Church has put on since 1995.
But isn't it fair to say that a reasonable observer could say, boy, I know that this play has been held on private property for the last 10 years, and now it's being held in the public park. The city must be part of it, they must be a sponsor of it, they must be wanting it to become more of a community event rather than a private event.
No, Your Honor, I think the popularity that it's grown out of the church, and I think anyone who would come and see the play and look at the cross would know that, and who was interested, they would know that the play could not be held in the church because it's just too popular now, and I think anyone familiar with the community would understand that.
Doesn't that make it all the more religious? I mean, what other message besides a religious message can come out of the passion play such as this? Isn't that an expansion of the very thing that the play is trying to portray? I mean, a very expansion of the beliefs that the play is trying to espouse. Namely, it's becoming bigger and bigger, and more people are coming into it. Isn't that
Into
a
the
religious...
fabric of the community?
Yeah.
Yes, Your Honor, and I would say that it's complete within the rights of the First Baltic Church to allow their religion to flourish based on the zeal of its adherents, as this court has ruled in Zorak versus Clausen.
In a public park?
In a public park, Your Honor, that has been open to a wide variety of spectrums. And I think...
For those who are not interested?
Pardon?
Before those who are not interested?
Those who are not interested do not have to attend, nor do they have to go to the park and look at the cross.
Why is
That's
it
certainly
unreasonable
open.
for the city to say, we don't want to leave an unattended cross in our public park for 3 days? Why is that unreasonable?
Your Honor, because they've allowed a wide variety of spectrums to be represented in this park in the past.
For 3 days?
We don't know from the record how long activities go on, but we know that this is not a time, place, and manner restriction, Your Honor. Rather, we know that the council is rejecting it because it's from a religious viewpoint.
How do we know that?
Because their stated reason was they don't want to violate the Establishment Clause. So we know that it's because of the religious viewpoint of this
Is that
ceremony.
explicitly stated and thought through?
Well, they thought through many issues. The Greater NERB Merchants Association said they'd extend the business period. But the issue they did decide on, as stated in the record, is that of Establishment Clause violation. So we know that the religion plays an important part in their decision. We find that under the precedent of this court, that it is viewpoint discrimination and axiomatically unconstitutional.
But the city's not telling you can't put on your play. They're just asking you to do it somewhere else.
No, Your
So
Honor.
how are they discriminating against your viewpoint?
Just like the school wouldn't tell Good News Club they couldn't meet in Good News Club, in the case in 2001, that they couldn't meet, just that they couldn't meet on school property. And this court has ruled that that is unconstitutional viewpoint discrimination. So based on the precedent of this court, that is so. Now, Your Honors, Capitol Square Review Board versus Pinette tells us that when you have a wide variety of opinions or a broad spectrum, those are the two phrases they use, applying both Widmar versus Vincent and applying Rosenberger versus University of Virginia, that there is an open forum present and that any and all comers can come. And we find that this is the case, even if they're religious, even if it's the first time a religious group has come. Now, petitioners contend that because there's no history of religious viewpoints being represented in this park, that we shouldn't allow it now, and this is patently false. Because we find that in Lamb's Chapel, as well as Good News Club, that it was the first time a religious club or religious organization applied for use of a public facility, and that was ruled constitutional because of the wide variety of spectrums represented from a non-religious viewpoint.
But again, Counsel, the uses that were allowed in the past were just plays. It wasn't anything. They didn't conduct a Shakespeare play and then leave, the sword stuck in the ground for 3 days. So this is something altogether different. The play takes place in a limited context. The play is over. People leave. They understand that this is a presentation of the church and not the city. Whereas leaving the cross there for 3 days, I believe it adds a different dimension, don't you?
No, Your
after your response.
No, Your Honor. The cross is completely connected to the play, and I think members of the community know that because this play has been performed in this exact same manner for the last 10 years. Thank you, Your Honors.
May it please the Court. My name is Lindsay C., and together with my co-counsel Joey Petrovich, I represent the respondents in the case at bar. Your Honors, the denial of the permit is an impermissible restriction of Reverend William Denoff's constitutionally protected rights to free speech and the free exercise of his religion for 3 independent reasons. First, this is an egregious example of viewpoint discrimination. Second, the action of the council represents animus toward a particular religious sect. And third, this is an... Your Honor, it does that because the decision was made to exclude the particular religious practice of the First Baltic Church. This is similar to the decision that this court referenced in the 2004 decision of Locke versus Davey. In Locke, this court relied heavily on a previous case, Lukumi Babalo I Incorporated versus Hialeah. In that case, the facts as cited in Locke were that a particular law was promulgated in order to stop the religious practice, ritual animalistic slaughter of the Santeria religion. Even though that law had the appearance of generality, this court held that the purpose of the law was directed from specific animus at a particular religious sect.
Wouldn't you say that in this case, where the city of Nur has since then gone on to say that no religious observances or ceremonies or anything will be conducted in the park at all, how can you say it's directed specifically at Reverend Denoff?
Your Honor, because it is, again, very similar to the Lukumi case, because there the law had the appearance of generality. However, because the initial purpose was to restrict the activities of a particular religious sect, it was found to be per se unconstitutional. In the case at bar, we see that the disagreement came from the Greater Nur Church Association, which objected to the different religious calendar that the First Baltic Church operated under, celebrating Easter 1 week earlier. We further see that the entire city council election was based, and the decision was made for members who were voted in specifically on their pro or anti-FBC sentiments. So the decision was made specifically by those who had the majority who were against the FBC and their particular practices. We can see this animus furthermore in the fact that it is not just a general prohibition of all religious celebrations in the park. It is aimed at particularly Easter religious celebrations, and it is the First Baltic Church, their Easter celebrations, which are different from those of the other churches in the Greater Nur Church Association, that is objected to.
Are they the only ones who differ?
Your Honor, we don't have any evidence in the record to say if there is anyone else. What we do have evidence is that specifically the First Baltic Church's practices who were being objected to by the community and by those members of the council who were voted for the express purpose of voting down FBC's approval.
So you think the permit process is not generally applicable to the community, or you think the denial of the permit is not generally applicable to the community?
Your Honor, if I understand your question correctly, the permit process applies to everyone, the two-part...
And isn't that the key?
Your Honor, we would contend it is not, because it's the policy when we're discussing whether animus is in place.
So simply denying the permit to somebody, whoever that may be, is ipso facto animus?
Yes, Your Honor, because...
So if a permit were denied for someone who wanted to run a fair, a bazaar of some kind, whether church-related or otherwise, if it were denied, then that would be animus toward that particular organization, in your view?
No, Your Honor, because as this Court has said in the 1988 decision of Frisbee v. Schultz, content-neutral time, place, and manner restrictions are permissible. So if it was just to restrict the activities in one of those categories, it would be permissible. Or furthermore, if it was not shown from particular animus toward a sect, but there was a compelling government interest that could be upheld, then the city might be justified in restricting an activity of that nature.
For example, if there were too many people, or likely to be too many people attending this passion play, the city would have been authorized to grant the permit?
Perhaps, Your Honor. If the city had, again, a content-neutral restriction on the number of persons allowed to attend a performance, because that doesn't particularly target the religion, perhaps it could have been acceptable in that instance.
Could have gotten around this whole thing very easily then, couldn't it?
Your Honor, had the city council had time, place, and manner restrictions under which this play fell, then it would not have been a violation of the free speech and free exercise rights. But that is not the case we have. In fact, this is viewpoint discrimination. As this Court has held in the 1995 decision of Rosenberger versus University of Virginia, whenever the government discriminates based on the message of the speech, then that is presumed to be unconstitutional. In Rosenberger, a religious student publication group was denied the same privileges that non-religious student groups received. And this Court found, because the primary difference was the religious nature and the religious viewpoint of that student group, that it would be per se unconstitutional to deny them the same access as the secular groups. This is again very similar to the case at bar. We have examples of other plays being performed in this park, and examples of other Easter celebrations being performed in the park. The reason that Reverend Denolf's application was denied was because of the specifically religious viewpoint of his Easter celebration, and that, as this court has held, is unconstitutional. Even as this court noted in the 1993 decision of Lamb's Chapel, if the city claims an interest in not violating the Establishment Clause. When other events and instances of speech have been allowed to occur, but the only distinction is religious speech being discriminated against, it is per se unconstitutional. Opposing counsel has argued that this is simply a matter of content-based discrimination, to simply remove all religion from the forum. However, in 1981, in Widmar v. Vincent, this court held that religion as a whole is an unacceptable content-based discrimination, that you cannot discriminate against all religion. There would have to be a difference in the compelling government interest. This court has also held in Good News Club, again, that viewpoint discrimination is automatically unconstitutional, and that an equal access policy, in fact, ensures neutrality, and that by allowing religious persons the same access to state grounds and services that non-religious persons have, that's how the neutrality of the First Amendment can be upheld.
So can the city of Nur ever decide that something that has religious content cannot be conducted in the park?
Your Honor, if the city could find an instance where there would be a violation of the Establishment Clause, then perhaps that could be justified. That would be a compelling government interest, but would also have to have a couple clarifications. The compelling interest must further be narrowly tailored. It must be the least restrictive means in order for the city to uphold its interests. But even so, there could be none of these instances, viewpoint discrimination, animus, or a prior restraint, because this court has held consistently that when even one of these presumptively unconstitutional measures exist, then this court won't even look toward whether the state has a compelling government interest because of the substantial nature of the fundamental rights of free speech and free exercise of religion. Your Honors, yes.
If we place the free speech issue against the political divisiveness or even possibly danger, if we move it to an extreme, how do you weigh in on that? If we think about this pragmatically now, and we don't look at the root necessarily religious, but look at one of the roots of the decision as the political divisiveness. You haven't really spoken to that yet.
Yes, Your Honor. First of all, the only political divisiveness this court has spoken about as potentially rising to this level of seriousness is that along religious lines, so it's impossible to separate the two. However, this court has also consistently held that political divisiveness...
But this would establish a precedent, okay, that would be broader than that. So we have to speak to that, I think.
Yes, I'm sorry, Your Honor, I'm not trying to avoid the question. This court has also consistently held that political division along religious lines has never risen to a level alone to constitute a violation. In fact, the divisiveness this court has spoken to is that comes from government programs. In the case of Lemon versus Kurtzman, it was a government program to give textbooks toward religious teachers. In the case of Lynch versus Donnelly, it was a government Christmas display that included religious elements. It is that divisiveness, when the government is doing the program, and that creates religious divisiveness, that the First Amendment was intended to protect against.
Isn't that what the city of Nur is trying to avoid, is having the community believe that this is a government-sponsored play and a government-sponsored symbol, the cross being in the park for 3 days?
Your Honor, that is the claim of the city. However, this court has never held that claim of an Establishment Clause violation is compelling enough unless it can actually be substantiated. And there is no case law that would substantiate that, because we see that, that where there's an equal access policy, there is no perceived government endorsement. And as this court's decision in Capitol Square Review Board versus Panett tells us, the erroneous conclusions of a reasonable observer do not count. There is simply no perceived endorsement. Finally, Your Honors, this is also an example of a prior restraint. As the case of Nemotko versus Maryland has said, when there is an issue of fundamental rights and there is no clearly articulated standards for who is and is not allowed to exercise these rights, then it is again per se unconstitutional.
The opposing counsel has said that the Establishment Clause itself provides the standard that they're abiding by. Isn't that, you don't agree with that?
Your Honor, that standard, the same concerns would have existed in the Nemotko case, whereas it was religious persons wishing to have a religious discussion in a park. This court held there that mere Establishment Clause claims alone is not enough to be clearly established guidelines. They also made a distinction because where there is a permitting process at all for the application and exercise of fundamental rights, that process alone is suspect, and that it requires very clearly articulated standards. And so the simple idea of claiming the Establishment Clause doesn't rise to that level. Your Honors, if the Establishment Clause exists for anything, then surely it must protect, may I conclude? Thank you. Then surely it must protect the rights of the religious minority from suppression by the majority. And it's for these reasons that I ask this Court to affirm the decision of the Court below. Thank you.
Petitioners would like to address several points made by respondents. First is that this is animus towards religious activity and that this is unconstitutional viewpoint discrimination. That is simply incorrect, and that is simply the respondent looking at the intent of the legislation. In the U.S. versus O'Brien, this Court cited that a governmental activity cannot be invalidated based on its legislative intent. What the City of Nur is worried about is the content of the speech. An unattended cross sends a definite message. It's not a perceived message, as respondents have said. It's a definite message to the broader community, the demonstration of approval, which the Establishment Clause is seeking to avoid. Now again, respondents have cited several cases showing that there is no Establishment Clause violation. Cases such as Rosenberg, cases such as Neamico, cases such as Capitol Square. What they failed to do is say that the Establishment Clause is not a fixed per se rule. In other words, the Establishment Clause must continually be looked at by the unique circumstances of that specific activity. In a case such as Neamico, there were other religious groups that had utilized that park before the Jehovah's Witnesses had come to use that park. In essence, in that case, they were showing considerable hostility to a specific religion. That is not what the City of Nur is doing in this given instance. They're responding to a highly divisive issue during a highly divisive time period, during a Easter season, which cannot be uniformly discussed by the City of Nur, and they're responding to that.
Council has pointed out that this is specifically directed at the First Baltic Church and Reverend Denolf because of the play itself and the divisiveness that it's caused in the community. Is that true?
Certainly not, Your Honor. And I would cite the policy itself. Again, it does not say that we're targeting the FBC. It does not say only the FBC cannot utilize this park. It's saying we will deny all future Easter applications by the FBC or any other church group. This is a narrowly tailored means to comply with the Establishment Clause based on the issue at hand, based on the facts of this case.
But that was ex post facto, wasn't it? The decision had already been made to deny this church's application. Now, in the future, there's going to be other things, but as to this church alone, it's ex post facto, isn't it?
Certainly, Your Honor. Your Honor, the city is trying to prevent this from happening again. This is exactly why this case is before this court. We're trying to prevent the political divisiveness that was present, the possible entanglement. City elections should not turn on religious viewpoints or religious thoughts and processes. The principle of the Establishment Clause is to prevent that entanglement.
It's creating the entanglement, though. That's my point. Isn't it creating an entanglement as opposed to preventing it? Yeah, for the future it may prevent it, but in this case it's creating the entanglement.
Certainly not, Your Honor, and I think I would look at the permit process itself. Again, Samantha Sutherland initially allowed the process, but the City Council had divisiveness over the issue. And in fact, what took them so long, or what could have taken them so long to decide this case was trying to not violate the Establishment Clause. If they had made a quick decision and said, oh yeah, go ahead. May I finish? This could have demonstrated that approval that the Establishment Clause was trying to avoid. This is not animus towards religion. This is trying to be neutral on religious beliefs. And the city is doing that with a narrowly tailored policy that is governed by the mandate of the Establishment Clause. Thank you.
Wow. We will be back.
Before I begin, let me ask for a round of applause for both teams. We've seen a lot of competition, and this was as high a level as it's going to get. I mean, that was really good all the way around. Also, let me thank the judges who did a wonderful job on that panel, too. Okay, the court's just going to give you a little feedback, announce the winners, and then we'll bring you up for awards.
When I said wow, I really meant it. This is as good as it gets. The four of you and all the rest of the participants in this competition are a tribute to your generation, and I can only see good things from all of you. 5 of us went outside, and I have to tell you, this is my, I think, 3rd year at the finals, and this is as close as it gets. It was a split decision, and everything was very close. We generally reached a consensus on all 4 of you, and particularly you, Lindsay, and you, Matthew, did an excellent job responding to the questions, keeping eye contact, doing all of the things that were required. Absolutely a terrific job. Joey, you did a great job as well. You focused on it, you have a knowledge, and you handled the questions very well. And Allison, you as well. You made eye contact, and you stayed with it, and handled yourselves very well. With all of that as the background, and again, an extremely close decision, we have decided that the petitioners, Matthew and Allison, prevail. Congratulations.
All right, so let's have the runners-up, Joey Petrovich and Lindsay C. And the 2005 Eastern Regional Champions from the University of Albany, Allison Bain Lucy and Matthew Woodward. Championship trophy for the school. It's our 4th competition, our 3rd different school champions. So happy to see that. So congratulations, University of Albany.